Good afternoon, everyone. Welcome to the final round of the 2017-2018 Hale Moot Court Honors Program competition. My name is Zoe Steinberg, and I am the chair of this year's program. The Hale Moot Court program was established in 1948 by a group of law students and was named after the dean of the law school, William Green Hale. Over the years, the program has evolved into one of the law school's most prestigious honors programs. At the beginning of the academic year, the Hale Moot Court competition commenced with 40 of the most outstanding advocates in the second-year class. Each of the students was selected based upon his or her excellent performance, both orally and in writing, during the qualifying rounds at the end of their first year. 16 of the students advanced to the quarterfinal rounds, 8 to the semifinal rounds, and finally, 4 were selected to argue in today's final round. The final round represents the culmination of their dedication, perseverance, and excellence throughout this year. I am delighted to welcome you here today to support the program and its participants, and to celebrate the remarkable achievements of this year's 4 finalists. They are Stephen Ehart, Alexandra Highsmith, Alexandra Jackson, and Alyssa Moskrop. Please join me in congratulating each of them for their successes in this year's program. At this time, Dean Guzman would like to say a few words of welcome.
Well, good afternoon, everybody. It's great to see you all here. Welcome to our Moot Court competition, and thank you so much for being here. I want to start with a couple thank yous, and then I will have very little to say after that because I want us to get on with the main event. I want to thank first Edward Lewis, who has provided support for the Moot Court competition that includes the Edward Lewis Award that goes to the winners of the competition. This event, the Moot Court, is one of our signature programs at the law school, and it's one of the events that we look forward to all year to have this final round featuring our students. And every year I have this tremendous feeling of pride at seeing the quality of the work that's being done, the quality of the advocacy that we see. So congratulations to the student participants, but also congratulations to the executive board who put it all together. I want to thank and recognize Professor Rebecca Lonergan, who is the faculty member who guides the entire process. And by that I mean 2 separate processes, really. That is the execution of the Moot Court in an administrative, organizational sense, but also the advocacy that's being done by the students involved from the beginning all the way through to the end. And of course, the participants. I want to congratulate all of the students who participated in the Moot Court this year. I have no doubt that for each of you there was a lot learned, and I hope you enjoyed it. It is one of those experiences in law school that people carry with them for a long time. And of course, I want to congratulate the finalists. I had the good fortune of judging the semifinal round, so I can testify for our judges that these people are prepared and capable and will do a great job. And last but not least, I want to thank our judges, Judge Stephen Higginson, Justice Carlos Moreno, and Chief Justice Stephen Tyler. Thank you so much for coming here and supporting our students and our school. Your presence makes the whole thing hold together and gives it a realism that's so essential to our success. So with that, I want to again thank everybody who's here. You're in for a treat. On with the show.
Good afternoon. My name is Tyler Franklin, and I'm the Administrative Vice Chair for this year's program. I'm going to give you the factual background of the arguments you're about to hear, so bear with me. This case comes before the United States Supreme Court presenting 2 important copyright issues. The first, whether the district court erred in determining that a defendant's digital sampling of a copyrighted sound recording was de minimis, and that the de minimis exception applies to sound recordings under the Copyright Act of 1976. And second, whether the district court erred in holding that a copyright registration does not become enforceable until the Register of Copyrights either approves or denies a copyright registration application, even though the effective date listed on the copyright registration certificate is the date the involved application was received by the Copyright Office. As for the procedural history and facts of the case, Emily Stierwalt and Nick Paul met while they were music majors at Southern Gould University. In early 2012, Stierwalt created and recorded 5 electronic dance music, or EDM, songs for her senior project. She used a technique known as found sound, which involves the use of everyday sounds to create unique digitally produced music. For example, Stierwalt recorded puff machine sounds at her local dry cleaner. She then mixed the found sounds with the sounds of musical instruments and sounds she created on her computer. Stierwalt gave Paul a flash drive containing recordings of her 5 songs, including one entitled You're Not That Innocent, which prominently featured a puff machine sound. Paul encouraged Stierwalt to post her songs on an online streaming platform known as SoundSpace, where artists can upload their music to allow public access. In April of 2012, Stierwalt uploaded her song You're Not That Innocent to her SoundSpace page. The song went viral, gaining 500,000 streams in the first week. On November 3rd, 2012, at the suggestion of one of her music professors, Stierwalt filed an application with the Copyright Office to register her copyrights for the musical composition and sound recording in her song, You're Not That Innocent. She did not apply at that time to register her copyrights for her other songs. In late 2012, Stierwalt and Paul had a falling out and never spoke again. Stierwalt never got the flash drive back from Paul. Later, in February of 2013, Stierwalt uploaded another of her songs, I Took a Nap in Ibiza, to her SoundSpace page. That song was not as popular as the first. After her second song was criticized, in April of 2013, Stierwalt decided to stop pursuing music and instead accepted a 3-year volunteer position teaching music in rural Africa. While in Africa, Stierwalt had limited telephone and internet access and was only able to check her email approximately once a month. On June 30th, 2013, while Stierwalt was in Africa, the Copyright Office issued copyright registrations for the musical composition and sound recording of her song, You're Not That Innocent. The certificate listed November 3rd, 2012, the date her application was received, as its effective date. Meanwhile, in January of 2014, Paul decided to begin producing his own EDM songs, using a variety of sounds, including original recordings of instruments and everyday noises, as well as some short digital samples of pre-existing sounds. One of the sounds he copied was a 4.5-second sample of a puff machine sound from Stierwalt's song, You're Not That Innocent. He remixed that sample and incorporated it into his own song, Oops, You Heard It Again. He also copied larger samples of sounds from Stierwalt's song, I Took a Nap in Ibiza, and incorporated them into his second song, Deja Vu. The melody and lyrics of Deja Vu were also very similar to Stierwalt's song, I Took a Nap in Ibiza. On January 15th, 2014, he posted both of his songs on his SoundSpace page. Almost immediately, some of his fellow musicians complained to Paul that the song Deja Vu was similar to Stierwalt's song. So on January 22nd, 2014, Paul removed Deja Vu from his SoundSpace page. He never reposted or otherwise published that song again. Meanwhile, before Deja Vu was removed from Paul's SoundSpace page in January of 2014, Stierwalt received an email from a friend suggesting that she listened to Paul's song on SoundSpace page. When Stierwalt listened to Paul's song, Deja Vu, she immediately noticed that it sounded very similar to her song, I Took a Nap in Ibiza. Upset by that copying, she listened to his other songs. She came across Oops, You Heard It Again, and after listening to about half of it, realized that Paul had used her puff machine sound from You're Not That Innocent. Although she was upset, Stierwalt did not immediately do anything because she was in Africa. In August 2016, when Stierwalt returned from Africa, she learned that Paul had become a successful EDM artist during her absence. She listened again to his SoundSpace page and learned that his song, Oops, You Heard It Again, was still posted and was quite popular. Stierwalt then contacted an attorney. On September 1st, 2016, Stierwalt filed a copyright registration application for the musical composition and sound recording for her second song, I Took a Nap in Ibiza. On January 8th, 2017, Stierwalt filed her complaint. Count 1 alleged Paul had infringed her copyright in the sound recording of her song, You're Not That Innocent. And Count 2 alleged he had infringed both her copyrights in the song, I Took a Nap in Ibiza. Her application to register her copyrights in I Took a Nap in Ibiza was still pending at that time. On January 15th, 2017, Paul filed a motion for summary judgment, arguing that count 1 should be dismissed because the only thing he had copied from her song, Oops, You Heard It Again, was a de minimis found sound, and second, that count 2 should be dismissed because Stierwalt did not register a copyright in her song, I Took a Nap in Ibiza. On January 22, 2017, Stierwalt filed an opposition, supported by the sworn declaration of an expert in EDM, Isabel Vidro. As to Paul's song, Oops, You Heard It Again, Vidro stated that she concluded that Paul digitally sampled a 4.5-second puff machine sound from Stierwalt's song, You're Not That Innocent, and used that sound 6 times throughout his song, Oops, You Heard It Again. Vidro further stated that the puff machine sound was qualitatively and quantitatively important to both parties' songs. As to Paul's song, Deja Vu, the expert concluded that Paul copied and used a substantial number of sounds from Stierwalt's song, I Took a Nap in Ibiza, as well as copying some of its melody and lyrics. In February of 2017, the Copyright Office granted Stierwalt's application to register her copyrights in I Took a Nap in Ibiza. The statute of limitations for copying violations claims is 3 years. The date the Copyright Office granted Stierwalt's application, February 8, 2017, was more than 3 years after the date when Paul first published his song, Deja Vu. However, the effective date listed on the registration certificate was September 1, 2016, which was within the 3-year statute of limitations. The district court granted Paul's motion for summary judgment, but the 12th Circuit of Appeals reversed the district court on both issues and remanded the case to the lower court. Paul filed a writ of certiorari to the United States of the Supreme Court, which was granted. We will now hear oral arguments on both issues. This afternoon, Stephen Ehart and Alyssa Moskrop will argue on behalf of the petitioner, Nick Paul, and Alexander Jackson and Alexandra Highsmith will argue on behalf of the respondent, Emily Stierwalt. And at this time, I'll invite our chair back to the podium to introduce our judges.
Thank you, Tyler, for that summary of the facts. The board is proud to introduce the 3 distinguished members of our legal community who will serve on our judicial panel this afternoon. Today's Chief Justice is retired California Supreme Court Justice Carlos R. Moreno. Justice Moreno received his BA from Yale University and his Juris Doctorate from Stanford Law School in 1975. Justice Moreno began his legal career in the Los Angeles City Attorney's Office. He later joined Mori & Ota, where he worked in the firm's general commercial litigation practice. Justice Moreno's judicial service began in 1986 when he was appointed to the Los Angeles Municipal Court by California Governor George Deckmajian. He was later elevated to the Los Angeles Superior Court by Pete Wilson. In 1997, Justice Moreno was nominated by President Bill Clinton to serve on the United States District Court for the Central District of California. In October 2001, Justice Moreno resigned from the District Court and was appointed by Governor Gray Davis to serve on the Supreme Court of California. He served on the court until 2011 when he retired. He then became of counsel with the law firm Irell and Manella. Finally, in April 2017, Justice Moreno began working as a mediator and arbitrator in Los Angeles. Also judging this afternoon is the Honorable Stephen A. Higginson. Judge Higginson currently serves on the United States Court of Appeals for the Fifth Circuit. He was appointed in 2011 by President Barack Obama. Judge Higginson received his A.B. from Harvard College, his Master's of Philosophy from the University of Cambridge, and his Juris Doctor from Yale Law School. During law school, Judge Higginson served as the editor-in-chief of the Yale Law Journal. After law school, Judge Higginson served as a clerk for Judge Patricia Wald of the United States Court of Appeals for the District of Columbia Circuit. He then served as a clerk for Justice White on the United States Supreme Court. After his time as a clerk, Judge Higginson worked as an assistant United States attorney in the criminal division for the District of Massachusetts until 1993, when he began working in the Eastern District of Louisiana. In 1995, he became chief of appeals, but still worked part-time as a prosecutor while he supervised the appellate section. In 2004, he became a full-time faculty member at Loyola University, New Orleans College of Law, where he worked until his appointment to the federal bench in 2011. Also judging this afternoon is the Honorable Stephen W. Taylor. Justice Taylor served on the Oklahoma Supreme Court from 2004 to 2016 and was Chief Justice from 2011 to 2013. Justice Taylor received his BA from Oklahoma State University and his Juris Doctorate from the University of Oklahoma College of Law in 1974. In 1974, Justice Taylor began serving active duty in the United States Marine Corps. As a Marine, he served as a prosecutor, defense counsel, and ultimately as a special court-martial judge. After he retired from active duty in 1978, Justice Taylor was the mayor of the city of McAlester for 2 years. In 1984, Justice Taylor began his judicial career as an associate district judge in the Oklahoma courts. In 1991, he was the first associate district judge ever to be elected president of the Oklahoma Judicial Conference. From 1994 to 2004, he served as chief judge of the 18th Judicial District. During that time, he presided over more than 500 jury trials, including the state trial of the Oklahoma city bombing case. In 2004, Judge Taylor was appointed to the Supreme Court of Oklahoma, where again he served as Chief Justice from 2011 to 2013. Justice Taylor retired from the Supreme Court in December 2016. The arguments today will last approximately 1 hour. At this time, please ensure that all cell phones have been turned off. Please also remain seated and as quiet as possible during the arguments. We will take a brief break following the conclusion of the arguments. And now we'll begin the final round. Bailiff?
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of the United States.
All right, please be seated.
Oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting.
All right. This is the matter of Nick Paul, petitioner, versus Emily Steyerwalt, respondent. The court has read and considered the briefs in this case and is prepared now to hear first from the first petitioner, Paul, on the de minimis issue.
Good afternoon, Your Honors. Stephen Ehart, co-counsel for petitioner Nicholas Paul. Your Honor, at this time, I would like to reserve 1 minute for rebuttal.
Very well.
Thank you. This afternoon, my co-counsel, Alyssa Moskrop, will argue that this court should affirm the district court's ruling on the copyright registration issue. I will argue for 2 reasons that this court should affirm the district court's rulings on the de minimis issues. First, the long-standing de minimis exception applies to sound recordings. The Copyright Act's plain language and legislative history extend the exception to all copyright categories, including sound recordings. Second, Ms. Steyerwalt cannot prove her copyright infringement claim because the undisputed material facts show that no average audience is able to recognize the 4.5-second sample in Mr. Paul's song.
Counsel, how would you define for this court the meaning or definition of de minimis? Because I have some real concern here whether or not, on the record that I've seen, whether or not the samplings here are, as they were applied to the respondents' music, were actually de minimis.
Your Honor, there are 3 different ways that the de minimis exception has applied to copyright law, and it has done so at least since the mid-1800s. One of those is the typical way that it applies to any law passed by Congress, which is that even though the plaintiff can meet all of the elements that they need to meet, the court says this is just so trivial, there's no harm here, and so therefore we're going to throw it out.
Well, let me stop you right there. As I understand it, again, from reading the record and the declaration of the expert witness, that the song in question, the original song, is 4.5 minutes in length.
Which
And
original
the-
song, Your Honor? Mr.
this-
Paul's song or Ms. Stierwald's song?
Ms. Stewart's song is well, actually, it's Mr. Paul's song, 4.5 minutes. The samples are about 4.5 seconds each, used 6 times.
Mm-hmm.
That amounts to about 27 seconds on a overall composition of 274 seconds. So it's about 10%. Now, is 10% de minimis, or is that something else?
Your Honor, the copyright infringement issues are all very fact-specific. So 10% doesn't necessarily mean that it is substantial enough to satisfy the second element of a copyright infringement claim. In this case, it's not, because the material undisputed facts show that an average audience wouldn't be able to recognize it. In particular, Mr. Paul changed the sound significantly, just as the...
It's hard to, the title of the song is Oops, right? Is that correct?
Oops,
Yeah.
you heard it again, Your
But
Honor.
it wasn't oops that he took hers. This was a deliberate and intentional act.
That's correct, Your Honor. Mr. Paul has conceded that he copied the
And
sound.
aren't we, Congress said entire, we sort of stopped there. The Sixth Circuit was right, and Congress lived with the Sixth Circuit's rule for 10 years.
Your Honor, that word entire is not related to, that word entire is tied to the fact that Congress was specifically allowing others to copy, to imitate entire sounds. So in that case,
Well, it speaks of the entire fixation. It's easy to read that as sort of giving us the Sixth Circuit's bright line rule. Even if you could interpret it later, it's undisputed that Congress seemed to approve of for at least 10 years the Sixth Circuit rule.
before that, Your Honors, the de minimis exception had applied since the mid-1800s. I think it's fair
Well,
to...
in other fields.
Correct,
The
but-
question here is, should it apply to the Copyright Act? And if there's statutory language that says it shouldn't, why would we put it in?
Because there is no statutory language, Your Honor. If you do look at the Sixth Circuit's ruling in Bridgeport Music, they do a very cursory statutory analysis. Essentially, everything that they do relies on that word entirely. And even in Nimmer's treatise, which this court has used to get information about copyright law, says that that word entirely does not suggest that the de minimis exception does not apply. Instead, it clearly delineates that sound recordings are a very limited copyright protection. Congress intended to allow imitation, and that's what that word entirely
The
does.
Copyright Act is premised on a constitutional provision.
Yes, it is.
Can you give me any constitutional case where we allow a constitutional violation to be de minimis?
Your Honor, I not off the top of my head, but the fact is within copyright law, this is what Congress intended to happen. And we know that because Congress knew that the de minimis exception had applied for decades. And when they updated copyright law in the Copyright Act of 1976, they had an opportunity to clearly state...
But how is stealing just de minimis? How can you call a theft a trifle?
Your Honor, because it's about whether there's any harm. And the harm here, there is no harm in this theft. Courts have consistently stated that harm happens when an average audience is able to recognize the original sound in the new work. And in this case, an average audience is not able to recognize that sound, and therefore there is no harm to the original
But
copyright owner.
weren't the breaks in one composition really the same in the other composition? You know, the digital sampling that was taken, it seems that they were at the beginning, at a break in the middle where there's a chorus. The two compositions are almost identical with respect to the use of the puff sound.
The placement in the song is somewhat irrelevant, Your Honor. If you look at what else is happening in the rest of the sound, they're not just the puff machine sound is not an isolated sound in Mr. Paul's song.
I would grant you that.
There's a number of other things happening, and it's about the overall feel of what a general audience would, whether a general audience would recognize the sound in the song.
And that's where I have some trouble on the vagueness of this de minimis as it applies to this case.
That's inconsistent results is the concern that I've got, is particularly for trial courts. Applying the de minimis standard is quite subjective, it seems to me, because then you get into, and the wording that was used was recognizable by an average audience. And so you leave trial judges with a standard that is fleeting, it seems to me, that recognizable by the average audience. What does that mean in the law?
Your Honor, honestly, it's no different than what the courts do regularly to determine whether a reasonable person would do something. It's whether listening to it, looking at what the Ninth Circuit calls a common sense analysis. And again, this is at summary judgment. Judges know what their responsibility is at summary judgment. They are supposed to give reasonable inferences to the non-movement. So, Your Honor, I don't think that there is a strong concern here that judges are just going to unnecessarily rule that the de minimis exception applies to a case.
Puff sounds, which I learned about as I was reading this record, puff sounds from a dry cleaner seems quite unique. That would, for an artist to decide that puff sounds from a dry cleaner constitutes some form of art, and then to incorporate it into the art. My concern is then that Mr. Paul took these, I don't know of any other song that has puff sounds, and then Mr. Paul turns it uses it 6 times, puff sounds, as the Chief Justice pointed out, in a 4-minute song. 6 times we've got these puff sounds, which is probably only the 2nd time in music history that puff sounds were used.
Perhaps puff sounds, Your Honor, but if we look more globally...
Is that de minimis?
It is de minimis, Your Honor, because if we look globally here, found sounds are used throughout EDM music. It's a popular art form, and artists are continually trying to determine new sounds and new exciting ways to share with general audiences a way to experience EDM music. Ms. Stierwald is not unique in the fact that she uses found sounds. Mr. Paul even uses and makes his own. So in that way, it's not unique. What matters here, again, is whether or not an average audience is able to recognize that Mr. Paul copied that sound, and they aren't able to do that. One point in the record, Your Honors, is the fact that Mr. Paul's friends, who are musicians and therefore are more knowledgeable than an average audience is, they did recognize the similarities between the different song by Mr. Paul and a different song by Ms. Stierwald, and they told him specifically about those similarities. But when it comes to this song, those musicians never mentioned anything to Mr. Paul.
Well, is that in the record?
It is, Your Honor. It is in the record.
That they didn't tell him about the similarities or in the first piece?
Yes, in the record at page 4, Mr. Paul's statement.
But it's also in the record, that it's undisputed that the segments were more than 3 seconds. So in England, this would be per se a violation, right?
I'm not aware of English law, Your Honor. If that's true, that it would be, but I'm not aware
But
of
these
that.
are 4-second segments.
These are 4.5 seconds.
And even if it would be difficult for your client to pay, your client could at least have acknowledged, but he didn't do that either.
It's not what the law requires, Your Honor. The issue here is not the Sixth Circuit and Ms. Stierwald, and now, unfortunately, the 12th Circuit have all made a big noise about the fact that this is stealing. Courts have never just simply said stealing. That's why there are 2 elements for for plaintiffs to require. First, they have to show copying, and second, they have to show that it's substantially similar so that an average audience would recognize it, and therefore there's proof.
But you agree, normally de minimis means inadvertence. In other words, a party misses something. And we say, well, then that's harmless. But here you're asking us to apply overlook, forgive, de minimis, even though it was a deliberate and intentional taking.
I'm not asking that, Your Honor. What de minimis means, at least in copyright law, is that the harm is so trivial that there's just no reason to say that there's a violation here. And that's why it has been developed both as an affirmative defense. So even if the plaintiff can prove both elements of copyright infringement, the defendant can say, look, yes, she made it, but there's no harm. It's so trivial. She hasn't shown that there's actually been any harm. And then it has developed also in a second way that the plaintiff must prove as a second element. So copyright law is very concerned about the plaintiff actually being able to show that there's some harm. And Ms. Stierwald is unable to do that here.
Counsel, maybe you can help me here. I don't have the cases at my fingertips, but there is a case on this de minimis issue that deals with the distinctive quality of a horn, and another case that deals with the unique and distinctive quality of someone's voice that is readily identifiable. And I think in those 2 cases, help me here, I think the court found that those were not de minimis because of the uniqueness of those sounds. And those were like fractions of a second.
Your Honor, in respects to the horn, that is in VMG Salso LLC versus Ciccone. And in that case, they actually did say that was de minimis. It was a quarter-second sound, and like Mr. Paul, the record producer changed that sound significantly before he added to the sound. There was also a number of other musical instruments playing at the same time. And so the court rightfully noted that the district court correctly determined that summary judgment was appropriate.
So here you have a fraction of a second versus 27 seconds.
Again, it's not just about a time limit, Your Honor. It's about an overall look at what was happening in that song, and whether or not an average audience is able to recognize it. It's also important, Your Honors, we have been speaking to the second issue, but I want to point out how important it is for this court to rule that the de minimis exception does apply to copyright law, in particular sound recordings. The statutory language is clear about that. Legislative history clearly intended for for sound recordings to be a, quote, limited statutory protection, unquote. And they even said in a House report that sound recording copyright infringement occurs, quote, whenever all or any substantial portion, unquote, of a sound recording is copied. It's clear right there. Congress wanted the de minimis exception to apply because it only considered all or any substantial copying to be an infringement. But that's not the only reason, Your Honors. The purpose of the copyright law is also supported by applying the de minimis exception. As the district court correctly noted, the overall purpose of copyright law is to protect the original copyright owner without stifling future creativity. And what this bright line rule does that the Sixth Circuit developed and exempts sound recordings from the de minimis exception is permanently disfavor new artists and new creative activity by permanently giving a complete monopoly to the original copyright owners. That is not the purpose of the copyright law as Congress intended. It is not supported by the statutory language or the legislative history. Your Honors, we ask this court to affirm the district court's rulings on the copyright registration issue, on the de minimis exceptions. Thank you.
Thank you, counsel. Okay, we'll hear from the second petitioner for Mr. Paul on the question of the application registration issue.
Good afternoon, Your Honors, and may it please the Court. Alyssa Moskrop, co-counsel for Petitioner. At this time, I would like to reserve 1 minute for rebuttal. Thank you.
See.
The district court correctly utilized the registration approach to define registration under the Copyright Act of 1976, and thus properly granted summary judgment in favor of petitioner. This court should affirm the ruling of the district court for 3 specific reasons. First, the plain language of the Copyright Act commands the registration approach by specifying that merely applying for copyright registration is not the same as nor enough for actual copyright registration. Second, the legislature's intent to incentivize timely registration, create a robust federal register, and maintain the registration requirement are best effectuated by the registration approach. And finally, the Copyright Office, whose determinations are owed deference by this court, explicitly promotes the registration approach. Perhaps the best and most straightforward illustration of the registration approach can be found within the plain language of the Copyright Act itself. The plain language of the Copyright Act is very clear in only authorizing one single entity to register a copyright. And that entity—
When you look at 411, isn't the subject and predicate in the critical phrase referring to the filer? In other words, a civil action cannot be instituted until, and you finish the sentence for me.
Till registration has been made, Your Honor.
Till registration has been made. That implies that it's a focus on the filer. Filer can institute action, filer makes the registration. I don't see any reference to the Copyright Office.
The reference to the Copyright Office, Your Honor, exists in Section 410A of the Copyright Act. Section 410A authorizes explicitly only the Copyright Office to register an application by quoting the words, "The register shall register." Section 410A also provides an affirmative burden on the register to examine all applications prior to granting that registration.
So it's a process, but why couldn't we stop at mere if we're talking about right to sue, which only limits the filer? There is a process and different steps have to occur, but in 408 it looks like they're focused solely just on the filer. So for purposes of cutting off a right to sue, why wouldn't we say, you've done your job, the government agency may be slow and lazy, but we're not going to take away your right to sue because they're slow?
The copyright holder may have done their job under 408A, Your Honor, but the copyright holder's jobs under 408A are only conditions of copyright registration and are not sufficient. What is sufficient for copyright registration is examination by the register, is refusal to grant or granting by the Register of Copyrights, Your Honor. The Register of Copyrights is the sole entity that is authorized to register a copyright. And there are many important reasons for this. For reasons of judicial efficiency, it's important that we have an answer from the Copyright Office prior to a claimant's ability to bring suit in court. A claimant needs to know what burdens he or she must prove prior to litigation. There are simply some things that do not make sense to occur in the middle of a lawsuit, and a preliminary determination on a copyright matter claim is one of those things.
When you start out with your 3 reasons, right, one is plain language, the second was incentive, that's a policy argument, so we can't really listen to that. Then there's a deference point. But what about just looking at the circuit authorities? Fifth Circuit's a very impressive court, and it favors the application rule, and it did it once in '84, and then it does it 20 years later, having looked at the rest of the disagreeing courts. And the Fifth Circuit doesn't normally agree with the Ninth, but on this one point, the Fifth and the Ninth agree.
Your Honor, it's important to realize that there is a circuit split here, which means there are authorities on both sides. Only 4 circuits have explicitly adopted an approach, the 5th and the 9th for the application, and the 10th and 11th for the registration approach.
Is there a trend? What do the more recent cases indicate?
The most recent case, Your Honor, is from the 11th Circuit, and that 11th Circuit case rules in favor of the registration approach. Yes, the 11th Circuit case is Fourth Estate Public Beneficiary Corporation versus wallstreet.com, Your Honor, and that case rules in favor of the registration approach primarily because the plain language of the Copyright Act requires that the registration approach be the proper approach.
Now, how do we deal with the question that arises, like I think in this case, where a plaintiff is sort of in legal limbo, as Nimrod Copyrights would put it? Isn't there a reason for trying to clarify what the situation is?
Your Honor, that clarity comes prior to a lawsuit. It's unfortunate that copyright holders are forced to wait during this interim period that the Copyright Office has to take to examine an application, determine whether that subject matter is copyrightable, and thus make a final determination. But what's worse here is legal limbo and shifting legal entitlements during the middle of a lawsuit. The application approach risks giving all benefits of registration to one who may not have earned it, because a copyright application that is pending in front of the United States Copyright Office under the alternative approach is considered registered when the Copyright Office has not even had an opportunity to make a ruling on that claim.
But then the effective date relates back to when they filed, and that's the effective date of the registration. So there's some ambiguity here and uncertainty that this presents for plaintiffs and defendants as well.
Quite to the contrary, Your Honor, 410D does refer to the effective date in both title and the language of 410D, but the effective date of a copyright application, registration cannot be effective until the other statutory requirements of not only 410D, but the other provisions of the Copyright Act have been met. And these are all sections that require an affirmative burden by the Copyright Office. Section 410D itself even states that the Copyright Office must determine whether an application is acceptable. If a copyright application that is still pending before the United States Copyright Office is already considered registered, then we've thrown away the Copyright Office's obligation to make a ruling on that determination.
I would agree with that.
Isn't the purpose, one of the main purposes of the copyright law is to encourage creativity, in this case, creativity by musicians and artists, and that when they apply for a copyright, the fact that it relates back to the date that they apply, doesn't that lend a strong presumption that the application process and the application approach is the more in keeping with the purpose of the copyright law to protect creativity and encourage creativity.
Protection of copyrights and creativity are important goals of copyright law, Your Honor. You are correct. However, the registration approach does best protect the goals of copyright holders.
It's not,
But during, we've got cases here where there are 2 and 3 year periods of time where the Copyright Office is deliberating, reviewing, and I'm sure they're busy, but doesn't that create it doesn't allow the court system and the protection of the court system to be given to the artist?
Your Honor, the registration approach is essentially the precautionary approach. And the best protection for copyright holders is to assert ownership at the earliest time possible. The registration approach incentivizes timely registration so that more works might be able to be incorporated into the Federal Register. We can foresee the possibility under the alternative approach that the Federal Register would be restricted to only infringed works because copyright holders have no incentive to register timely. But under the registration approach, where copyright holders do have this incentive to register timely, we're essentially expanding that Federal Register to include more works, both infringed and non-infringed.
that's an argument. Certainly, Professor Nimmer doesn't agree with you on this. Fair to say?
Fair to say.
Yes. Have you found any scholar that agrees in terms of practicalities and incentives that we should cut off the right to sue? Do you know of any scholar looking at this problem?
Your Honor, Patry on copyrights does the exact opposite of Nimmer, although I would like to point out that these are secondary sources and not necessarily they are only persuasive value for the court and not something that the court is required to follow.
Well, the reason I ask is because if the issue is incentives, normally a statute of limitations kicks in when a party's been delinquent or lazy on their rights. But
Absolutely.
the registration approach would apply whether people were lazy or not. In other words, if the Copyright Office gets too backlogged, they could lose their right to sue.
That is true, Your Honor, and that's an unfortunate consequence of the Copyright Office. But Congress and the Copyright Office should be dealing with the defects in the examination process that require the Copyright Office to take so long. But this information is published for copyright holders, Your Honors. We know that it takes 6 to 8 months to register a copyright. That is not only published in the compendium of the Copyright Office, but it's published in the frequently asked questions pages on the Copyright Office website.
But your position does sort of ennoble and enhance the Copyright Office's role in this. But it isn't like the EEOC in that you can't get into court until they've ruled. This is a permissive structure, correct?
Registration is not required unless a copyright owner would like to sue for infringement.
What degree of deference should this court give to the Copyright Office?
Your Honor, the Copyright Office is entitled to Skidmore deference, but the extent of that Skidmore deference depends on a multi-factor test. Every one of those factors of which the Copyright Office has succeeded. The first of those factors is the thoroughness in its consideration and the validity of its reasoning. In Section 625.5 of the Copyright Compendium, the Copyright Office discusses both the plain language of the Copyright Act to support the registration approach, as well as Senate statements from the Senate and the legislative history that support the registration approach. Some of those statements include a provision by the Senate that states, quote, "A review by the Copyright Office of the validity of a copyright claim is a necessary precondition for enforcement of copyright protection under law." The Copyright Office, in discussing the plain language of the Copyright Act, also discusses the registrar's duty to refuse registration, the registrar's duty to examine, the registrar's duty to grant registration. Another one of those factors under Skidmore deference, Your Honor, is the facts which give the Copyright Office the power to persuade. The Copyright Office is the expert agency in United States copyright law, as well as those factors set out in Section 701 of the Copyright Act. The Copyright Office undoubtedly has the power to persuade. One of those roles and obligations set out in Section 701 of the Copyright Act, Your Honor, is that the Copyright Office advises Congress on copyright issues.
You would agree, however, that the ultimate arbitrator of what the law means and what it says is this court?
Absolutely, Your Honor.
And that deference is not abdication?
Correct, Your Honor. This court does has the ability to rule over the Copyright Office. However, in 1988, when the Senate chose to preserve the registration requirement, one of the reasons that the Congress kept registration was because it, quote, assists courts in resolving the underlying copyright dispute. The Copyright Office is supposed to assist courts and help courts. Without a role in copyright registration, the Copyright Office simply cannot assist the courts. And just as well, Your Honors, the Copyright Office and its role in registration is supposed to enforce and promote judicial efficiency. Only under the registration approach do we have clarity for both claimants moving forward in court, both the plaintiff who must protect themselves in court and the defendant who defends themselves against another
You
copyright
mean
holder.
judicial efficiency because you've got an absolute demarcation of sequence?
Judicial efficiency because we have the groundwork of the legal claim made prior to litigation, Your Honor. And
But it's also sort of brutally judicially efficient that you can't even get into court if the Copyright Office is too late or too slow.
It's a fine line to draw, Your Honor, but I'd like to point out that it's not only the Copyright Office. We're talking about a particular group of copyright holders who chose to wait to assert ownership, and therefore they have to wait to assert
She was in
protection.
Africa, right?
That is true. Mrs. Stirwalt was in Africa. However, Mrs. Stirwalt was not reasonably diligent. Mrs. Stirwalt could have registered her copyright in 2013 upon publication. Mrs. Stirwalt also could have registered her copyright prior to leaving for Africa. And arguably, Mrs. Stirwalt could have registered her copyright during the 3 years she was in Africa because the record does state that she had access to internet. As well, Mrs. Stirwalt admits in the record that on page 15 of the record that she was distracted and chose not to check her email once a month.
But it was her puff noise. And he could have acknowledged her, put aside the legality of all.
Your Honor, this claim does not have to do with the puff noise. That is a different song, but the song we are referring to.
This is the Ibiza, but my point is he could have acknowledged her. It was her segment.
That is true, Your Honor, but what's important to remember is that Mrs. Stirwalt did not register her copyright, and therefore this information was not published. Although Mr. Paul knew on his own personal circumstances that this was Mrs. Stirwalt's song, this court makes policy for the whole, for the nation as a whole. And copyright holders who publish this information in a timely manner allow this information to reach the public. They disseminate more and more copyright information into the public so that if someone wished to use the copyright claim, it's possible, excuse me, Your Honor, I see that my time is up. May I please briefly conclude?
Yes, please.
It's possible that copyright holders who do publish this information into the Federal Register then allow others to use their copyrights by finding their information, contacting them, negotiating something different. Your Honors, the registration approach is the best approach here because not only does it help enforce this protection and offer precautionary measures to copyright holders, but it is the most far-reaching protection for all. Thank you very much.
Thank you, counsel. Okay, we'll now hear from the first respondent, Stirwalt, on the question of the de minimis exception and whether it applies in sound recordings.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court, A.J. Jackson, co-counsel for the respondent, Ms. Emily Stirwalt. Today, my co-counsel, Alexandra Highsmith, will argue that this court should affirm the holdings of the 12th Circuit on the copyright registration issue. Likewise, I will argue that this court should affirm the holdings of the 12th Circuit on the de minimis issue because, one, the plain language of the Copyright Act of 1976, and two, its legislative history demonstrate that the de minimis exception cannot and should not apply to sound recordings because exclusive control over actual sounds goes to the sound recording copyright holder.
But both those are both difficulties for you, but you're about to do it. But the language does contemplate actions by the filer and the office. And if I'm not mistaken, the history to this, Congress explicitly was presented the thought of removing of the de minimis instruction and then chose not to put it in? Or, go ahead.
Your Honor, I'd like to address your questions in sequence, if that's all right. So first, speaking to the plain language, opposing counsel brought up the fact that Section 114B of the Copyright Act is limiting. Our argument is not that this is not a limiting statute. It is, in fact, limiting. What we need to look to here is the actual practical consequences of that limiting language. So here, the sound recording copyright holder does not have a source of recourse against an individual that closely imitates their work. That's a given. So what the sound recording copyright holder is thus left with then is control over the actual sounds. So to tell an individual like Ms. Steerwall, one, you do not have a source of recourse when someone closely imitates your work, and two, you also do not have a source of recourse when someone samples your actual work and takes it.
Snippets it, just takes a little bit.
Your Honor, given that the snippet here could be considered quantitatively small, again, the sound recording copyright holder's rights are exclusively over the actual sounds. So regardless of how small those actual sounds are, they retain value. Mr. Paul wouldn't have sampled this sound, regardless of how small it was, if he didn't recognize that value, if it wasn't saving him costs, if it wasn't promoting the value of his song and making it more popularized.
Well, what if he's just sort of an internet hobbyist, and he's just taking little microseconds, or he's an Andy Warhol type person, grabbing from all over and mashing them together?
And he's changing the
Yes.
composition in itself, so it's barely recognizable
Yeah, it's sort of
at all.
transformative, and it's
Yeah.
innocent, and I thought sort of de minimis doctrine, the maxim, as that your opposing counsel says, goes back centuries. The Supreme Court cites it in almost every field of law. So why only in copyright would we not acknowledge this triviality exception?
So Justice Higginson, earlier you stated that the song might be called Oops, You Heard It Again, but there's no oops here. I would argue then that this sampling was far from innocent.
Well, you
And-
look at both the compositions, and you're probably right.
Sure, yeah.
Do you, you know, we've talked about this concept about the average audience, which is intriguing to me, that we end up in a court of law dealing with that sort of definition. But do you agree that if an average audience didn't recognize this de minimis copying of sounds, that there would be no harm to the financial harm to the owner? In other words, if Paul's borrowing this sound, and if the average audience doesn't know that it came from Starwalt, then is Starwalt harmed in any way?
So, Your Honor, 2 points here. First, opposing counsel, yes, stated that the average audience member analysis is the correct approach to apply here to determine substantiality. We disagree. The average audience member analysis should come into play when factual copying is in dispute, and we've seen that in the case law. So you're not asking if an average audience member can recognize an appropriation to determine substantiality, but rather in those cases whether an average audience member can recognize a sample to determine whether or not copying ever actually occurred. Here, Mr. Paul has conceded that he took Ms. Steerwalt's sound without her consent for his own benefit. We're past that. We're now at the substantiality element, where we're looking to a objective, fact-based, case-based, qualitative, and quantitative analysis to determine how important this sound was to her work. And speaking,
Go ahead.
I apologize.
Let me just take you back to
Sure.
where you started. I'm interested in the interrelationship between Section 106 and 114. 106, which grants sort of broad copyright authority. You know, but when I look at the language of Section 114, it is, in my view, a limiting statute. It says sound recordings are limited to the rights specified. Section 106 is limited to the right to duplicate sounds. The exclusive right of the owner of copyright in sound recording is limited. The exclusive rights of the owner of copyright in a sound recording do not extend. So when I read 114, I see it as sort of curtailing the broad rights that are granted to any type of copyright in 106. Can you defend that, your position?
Your Honor, the language in Section 114B that you are referencing that is limiting also includes the language repeatedly, the exclusive right, which is critical to note. But here, again, looking to the actual practical consequences of what this statute does. So in most other copyright contexts, an individual has a source of recourse, again, against someone who closely imitates their work and then passes that off as original. Here, the sound recording copyright holder, because of the limiting nature of this statute, which we do acknowledge is limiting, in fact, is left with one exclusive control, and that is over actual sounds, no matter how small. That is the sound recording copyright holder's property.
How do we harmonize that with the rest of the statutory scheme, though, which, the other types of copyright protections are not afforded the special protection, as you would argue?
Your Honor, the special protection here, I would argue, is not actually a special protection. It's the only protection. So to, again, tell Ms. Steerwalt, one, you do not have a source of recourse when someone closely imitates your work, no matter how close they come. And two, you also don't have that source of recourse when someone takes your actual sounds, leaves her with essentially no rights in the reproduction.
But you focus so much on her. But when we go back to Article 1, what is it, Section 8, the focus is on the public here. So there is a lot of the Sixth Circuit moral outrage in what you're describing, but what's the limiting principle? I was asking earlier about the Andy Warhols or the true transformators. Why not just have this fair use, substantial similarity test? If the expert doesn't recognize it and even the author doesn't recognize it, then we say it's too small. You haven't taken it.
Your Honor, in practical terms, again, these tests don't always work efficiently in this context. For example, it's difficult for the court to sit here today, respectfully, to look to both a qualitative and quantitative analysis or to look to the petitioner's argument.
What's your limiting principle? Or do you sweep in everyone? Let's say we've got technological features that can even pick up a millisecond of use. That's still a violation? You have no limiting principle?
Your Honor, there would be, the limiting principle here is that sound recordings are inherently different. So if one wants to sample even that small of a portion, a license is needed. And this licensing scheme between individuals for sound recordings has been intact and has been working efficiently since the 70s.
Is that in the record?
Your Honor, it's not, but it's within the case law, it's within research by Professor Nimmer.
But probably opposing counsel would say this is not easy for little people to call up and pay and find the licensing. But you're saying it's a consensus that everyone thinks the licensing scheme's pretty efficient and works?
Yes, Your Honor, that is what we are arguing. Again, since the 70s, it's been an efficient scheme. Duke Press issued actually a recent article and a recent study on the actual pricing of those schemes. For superstar artists, say Michael Jackson in his prime, the cost to sample his recordings would have been between 12 and 14 cents per copy. For someone like Ms. Steerwalt, an up-and-comer, that price usually ranges from 4 to 5 cents. Again, if that licensing scheme is something that is an issue for an individual like Mr. Paul, he does have other options. He can go imitate the sound himself.
But the statute we're looking at is 20 years old, right? It precedes the internet, precedes digital music. Why wouldn't we put a little lubricant in?
Your Honor, sampling was common in the 60s and 70s. Yes, it has technologically advanced since then, but the issue with preventing record piracy, both of sound recordings as a whole and of their component parts, remains the same today. And if we actually look to the legislative history, we can see that. The Sound Recording Amendment of 71 was the predecessor to the Copyright Act of 76, and its goals were to prevent record piracy, again, not just of sound recordings as a whole, but of their component parts. And the 71 House report speaks to this. And I quote,
Ms. Jackson, speaking of legislative history, doesn't the legislative history as to Section 114 indicates that infringement occurs when substantial portions are copied? And are you taking the position here that this was a substantial copying?
Your Honor, I'd like to respond in a threefold way to that. There's a couple different points as to that language that's important. First, that language, the all or any substantial portion, needs to be taken in context. In that discussion of the legislative history, Congress was, again, contrasting the rights of an individual in a general copyright context to pursue recourse against someone closely imitating their work versus the more nuanced, limited rights of a sound recording copyright holder only over actual sounds. And second, while not disregarding the all or any substantial portion language, I'd like to redirect the court to the use of the term actual sounds again, because that is what is important here. And third, the legislature actually took tangible steps within the plain language of the Copyright Act itself in 76 to speak to ambiguities like the one that Your Honor just discussed. And that occurred within particularized language, again, distinguishing between imitations, the right to imitate, and the right over actual sounds. So the 71 language read that works of an independent fixation of other sounds were the types of works that could avoid infringement. The 76 Act added the word entirely. The legislator added that word to entail that only those works entirely of an independent fixation could avoid infringement. And again, this speaks to the fact that that imitations are freely allowed for sound recordings, which Mr. Paul was more than welcome to do, but he chose not to. He copied her work instead. And that because of those nuanced rights and because of those limitations, we have to be respectful of those actual sounds, even where they are
All right.
quantitatively.
Assuming without deciding that we don't agree with you on your initial argument on the applicability of the de minimis, on the merits of de minimis, what is your argument, your plan B?
So, Your Honor, our plan B, if the court chooses to disagree with our legal argument that the de minimis exception should not apply to sound recordings, is that this sampling was not de minimis to start off with, as it was both qualitatively and quantitatively significant to Ms. Stierwalt's work. So the qualitative significance itself hinges on a couple different factors, Your Honors. It hinges on uniqueness of the expression, expert testimony, as we've provided from our expert witness, Isabel Vidro, pages 18 to 22 of the record, and the discretion of the court. So here, this puff sound was used at key compositional marks in Ms. Stierwalt's original song, both at the entrance of each verse and at the chorus. And this is similar to the Sixth Circuit case that we saw Bridgeport, where an arpeggiated chord there, a guitar solo, was used to produce a high-pitched whirling sound that captured the listener's attention at key compositional marks. And additionally, this sound was unique and popularized on this platform. As Petitioner noted, found sounds are common in EDM. They often make the pinpoint of an entire song, and they are very creative and appreciated on these online platforms.
I guess my question is, this is like an everyday sound, and how is that a protectable interest?
Your Honor, we have to look to this everyday sound in context. This, again, as we discussed earlier, this sound was brought into this context for the first time. Page 12 of the record, Ms. Stierwalt notes that she didn't want to be like other EDM artists. She wanted to find her own newfound sound. She also remixed and rearranged the sound, specifically adding bass to make it unique. And that is why it deserves the protection that it receives under this qualitative inquiry.
But where would one draw the line in terms of what constitutes a protectable found sound? The honk of a horn, bridges, I mean, sounds that are, I've heard this before, someone's under a bridge and listening to the thumping of cars going by. That's a sound recording. Some might consider that music. But where do we draw the line into what is protectable and what isn't?
Sure, Your Honor. So in order to be copyrightable, there must be some minimal amount of creativity and originality met. So that would alleviate some of the court's concerns. But we do concede that's a valid concern to look to when is this sound both qualitatively and quantitatively significant enough to be protected. However, certain parts of music, so if we look to the basic building blocks of music, like a single beat, that's uncopyrightable. Everybody can use that.
Yeah.
So a lot of the sounds that you're discussing and that you would be concerned about being copyrightable would be held not copyrightable by the Copyright Office. If we also look to the amplified importance of this sound, it's critical, especially in this EDM context. This was different than what we saw in Chicone, the Ninth Circuit case here, where a single horn hit was sampled, transposed into a double horn hit, and was not recognized by an expert witness because it had so little impact on the original song. Here, our expert identified the sound, noted it was qualitatively and quantitatively significant, and this was predominantly an electronic piece, so it was...
Your client didn't recognize it at first, though, right?
Your Honor, my client didn't recognize it until halfway through the song. However, that speaks to the average audience member analysis, which we again would argue is not the appropriate test to use here because factual copying was conceded. And additionally, it's not a question of when or how much my client recognized, it's that she did recognize it. And that really speaks to the shortcomings of the petitioner's argument in this case. Additionally, if we look to the quantitative significance of this song, it was 4.5 seconds in length, repeated 6 times, making up a total of 27 seconds of the song, which was substantial. And Your Honors, I see that my time has run out. I'd like to briefly conclude and ask this court respectfully to affirm the holdings of the 12th Circuit on the copyright registration issue as well as the de minimis issue. Thank you.
Counsel. All right, we'll hear from your co-counsel, second respondent on the application registration dichotomy.
Good afternoon, Your Honors, and may it please the Court. Alexandra Highsmith, co-counsel for Respondent, Ms. Emily Stierwalt. A plaintiff's ability to enforce her rights should not be dependent on how long it takes the Copyright Office to process a pile of applications. For 3 reasons, this court should affirm the 12th Circuit's holding and adopt the application approach to the registration requirement of Section 411 of the Copyright Act, and consequently hold that Ms. Stierwalt had fulfilled that requirement by the time she filed her claim against Mr. Paul.
Ms. Highsmith, if we adopt the application approach for the whole country, then registration would occur when the copyright application is filed. Wouldn't that void the right of the Copyright Office to refuse an application after examination, and the process of examination would become meaningless?
Well, first, Your Honor, I would like to point out that the Copyright Office actually approves 99% of the applications that it receives. And to the refusal point, an applicant can sue whether an application is refused or approved. So it wouldn't make sense for this court to force authors to wait for that determination, given that they will have the right to sue regardless of that determination. Additionally, the Copyright Office's role in registration is simply to determine whether the materials submitted in an application are copyrightable. And under the application approach, the Copyright Office would still have to fulfill that requirement. The Copyright Office would still be required to accept applications and would still be required to add those deposit copies to the Federal Register. However,
once somebody applies, then they apply for a copyright, then the process of examination goes on by the Copyright Office, and in the meantime, the person who applied for the copyright could file a lawsuit, succeed in the litigation, recover damages when they really didn't have anything that was copyrightable in the first place.
Justice Taylor, I'd like to answer your question in two parts. First, if Your Honors look to Section 410C of the Copyright Act, 410D of the Copyright Act, a court of competent jurisdiction has the authority to determine whether the application materials are sufficient. And second, I'd also like to point out that the determination by the Copyright Office is not evidence of validity. Courts determine whether copyrights are valid or not.
But factually, there's no reason anyone in your client's position couldn't notify the Copyright Office that litigation is commenced. Could they expedite the processing?
Yes, Your Honor, my client could have expedited the process here, but what's most important to note is that the special handling function at the Copyright Office is simply a Copyright Office policy. It's not statutorily provided for. Thus, the Copyright Office could remove that requirement, that option at any time. And even if that option was there, the Copyright Office makes no guarantee that it could process an application in the time that it states. It's important for this court to note that the Copyright Office reserves the right to deny a request for special handling for any reason. And one of those reasons is if the Copyright Office is experiencing a significant backlog. And that's just another reason why it wouldn't make sense for this court to adopt the registration approach, given that at the point when an applicant has applied for registration, they've done all that they can do, and they're simply at...
But you're urging for the application approach.
Yes, Your Honor.
And that does seem to run into, we should maybe start at the text of this. It doesn't all of the text of the statute contemplate that the filer takes actions and the Copyright Office does various things. So the plain language is difficult. And correct me if I'm wrong, but the history behind Congress, didn't they contemplate removing this pre-suit requirement in the treaty world, and then they decided, no, we're going to leave it on Americans, not others?
Yes, Your Honor.
So doesn't the language that Congress chose, as well as pretty solid legislative history, show that they want this right to sue prerequisite?
Your Honor, I'll address first the legislative history and then the text of the statute, if that's all right. First, Congress did contemplate removing the registration requirement, yet declined to do so. However, the application approach doesn't get rid of the registration requirement completely. It simply allows an applicant to enforce their rights in court sooner. So we wouldn't be removing that, that requirement completely. Second, the text of the statute is far from clear. If Your Honors look to the text of Section 411A, it's unclear what actions are required for the act of registration. In that provision, it states that no civil action for infringement shall be brought until registration has been made in accordance with this title.
But if there's ambiguity, why wouldn't we defer to them?
To the Copyright Office, Your
Yes.
Honor? Well, the Copyright Office has largely embraced the registration approach. However, that interpretation is subject at most to Skidmore deference. However, this court shouldn't find that interpretation persuasive for a couple of reasons. First, the Copyright Office's investigation is not thorough. The Copyright Office has failed to acknowledge certain provisions of the Copyright Act that suggest that the application approach is correct. For example, the office fails to discuss Section 408A, which states that an applicant may obtain registration by delivering the requisite materials, which suggests that an application is effective as of submission. Additionally, it barely discusses 410D and never states that it's only related to remedies. It simply states that the effective date is the date on which those application materials are submitted.
Is there any significance to the phrase that's used, may obtain as opposed to shall obtain registration? May seems to imply that a process starts as opposed to actually getting the registration.
Right, Your Honor. But it's important for this court to note that the reason why the word may is used in Section 408 is because under the 1976 Act, registration was no longer deemed mandatory. So, and the title of that provision is registration permissive, which simply means that the copyright applicant does not have to actually apply for registration, whereas under the 1909 Act, that was a mandatory step. The word shall refers to the obligations that Congress has put on the Copyright Office. And so the shall is actually referring to the obligations on the office itself, while the may is simply referring to the idea that registration is a voluntary act now. However, that just lends further support to the application approach because the statute is ambiguous and doesn't thoroughly state what is required of an applicant before registration is effective.
You know, if we are seeking a national standard that would bring some certainty and consistency and pure objectivity, wouldn't we be wise to allow this process to take place and to let the experts at the Copyright Office judge this, administratively judge this application to determine if it meets the standards of the law before then we give this protection to the property that's being copyrighted? Seeking objectivity, consistency, and certainty.
Well, no, Justice Taylor. As stated previously, a court does have the power to determine whether application materials are sufficient and does determine whether a copyright is valid or not. And given that the Copyright Office does accept 99% of the applications it receives, it would make little sense to force authors to wait. The Copyright Office itself admits that its investigation of application materials is not thorough. In Section 602.4 of the Copyright Compendium, Your Honors, the office itself states that it does not conduct findings of fact as to the truth of any statement in the application, nor does it compare any deposit copies to any works already on file with the Copyright Office. This shows that the gatekeeper role of the Copyright Office is a limited one. And to force authors to wait for this determination when the examination is not thorough would be taking away from Congress's broader goal of protecting authors under the 1976 Act. Under the petitioner's approach, authors would have done everything that they could do, but would be waiting for this limited examination from the Copyright Office in order to institute their rights. And in that time lag, Your Honor, authors could suffer additional harm. I'd also like to point out that petitioner's argument that timely registration is an incentive that Congress intended to create is one that will still exist under the application approach. If Your Honors look to 410C of the Copyright Act, a copyright certificate is prima facie evidence of validity if obtained within the first 5 years of publication. Now, that certificate is only that form of evidence if obtained within the first 5 years, and that provision would still stand under the application approach and would still incentivize some authors to register in a more timely fashion.
Tell me again why the application approach you favor doesn't pit courts against the Copyright Office, sort of structurally.
Well, Your Honor, the Copyright Office's examination of a copyright application is still not determinative of validity. And given that the examination is limited, we can foresee instances in which two authors would submit applications for the same work, and because the Copyright Office does not compare any deposit copies to each other, courts would still have to determine who held the valid copyright there. And given that Congress's intent was to protect authors and to remove some of the formalistic requirements of copyright law, the registration approach wouldn't make sense because there would be a time lag. Additionally, going back to timely registration, the statute of limitations set forth in Section 507 of the Copyright Act is 3 years. The registration approach would impermissibly cut that statute of limitations. Under the registration approach, authors would have little notice as to when they actually had to fulfill the requirements of 411A. They couldn't look to the copyright law to determine when they had to file. Now, petitioners argued that those time lags are published on the Copyright Office website, but again, that's no guarantee. It doesn't state that for sure the Copyright Office will act within 8 months, and in instances it has taken longer. So it would seem odd, Your Honors, for this court to adopt a rule that gave applicants little notice as to what requirements they were forced to comply with, given that Congress intended to protect authors under the 1976 Act.
We've got a clear split, 4 circuits.
Yes.
Where are the scholars on this? Do the scholars agree with a very liberal application rule, or do the weight of scholarship in this area, expert viewpoints favor, let the whole process take its course?
Well, Your Honor, Nimmer on copyright, which is the foremost expert on copyright law, does adopt the application approach. And he argues that the registration approach would leave applicants in a period of legal limbo where they were unable to enforce their rights despite doing everything that's required of them under the Act. The registration approach leaves applicants at the whim of the Copyright Office, and any delay at the Copyright Office would not be something that they could control, and those delays could come up for any reason. And the Copyright Office's examination is limited, so it doesn't make sense to force authors to wait there. Additionally, Your Honor, the application approach results in more efficient verdicts for plaintiffs and defendants. Authors can enforce their rights more immediately and will receive a determination from the court sooner under the application approach.
Do you have any response factually to the suggestion your client sat on her rights?
Well, Your Honor, Ms. Steerwalt was in Africa, and she was inhibited by her commitment in Africa. She was inhibited by that commitment and could not file earlier. However, it's important to note that Ms. Steerwalt isn't alone in these situations. There are certainly instances in which authors were unaware that failing to register would render their claim, would disallow them from bringing a claim, Your Honor. And the registration approach reads the statute into a requirement that doesn't actually give applicants notice of what requirements they have to fulfill.
Should this court be concerned about claimants who sit on their rights and don't take appropriate and timely action?
Well, Your Honor, is Your Honor asking about timely registration or the timely filing of a suit?
Timely registration.
Timely registration? Well, Your Honor, I'd like to point out for the court that under the registration approach, an applicant can still wait until the date of infringement to file a copyright registration. There's nothing in the statute that prevents someone from waiting 50 years to file a copyright registration. The only evidence of Congress intending for someone to file close to publication is 410C, Your Honors, where it gives plaintiffs that prima facie evidence of validity. But that, again, still stands under the registration approach. Under the application approach. Under the registration approach, an applicant can still wait until the date of infringement in order to file suit.
I thought I saw the Seventh Circuit had an opinion in this. They're not one of the 4 in the split.
Right.
Did Judge Posner have a brilliant insight, or is he confused on this?
Your Honor, Judge Posner in the Chicago School Board decision leaned towards the application approach for—
Leaned towards.
Yes. There was not a formal adoption of the application approach there. But I'd like to point out for this court for a moment that there are unintended consequences of adopting the registration approach. Let's suppose for a moment that the timely registration argument is correct. If applicants flood the Copyright Office with copyright applications, we can certainly see that the delay at the Copyright Office would be longer. And in that instance, that cut into the statute of limitations would be even longer, which would, again, rid applicants of their ability to sue simply because the Copyright Office is backlogged. And given that that examination is extremely limited, it doesn't make sense for this court to adopt an approach that would fail to protect authors, especially when Congress intended to get rid of formal requirements in favor of more practical ones. Your Honors, Congress said that it intended to induce registration in a practical way, but it would certainly be impractical to allow authors to file an application yet not be able to enforce their rights. Your Honors, the registration approach stifles the very creativity that copyright law was designed to foster. And a plaintiff's ability to enforce her rights should not be based on how long it takes the Copyright Office to sift through a pile of applications.
Is that really our function, how efficiently the Copyright Office functions?
No, Your
Are we
Honor.
to remedy problems of their own creation and Congress's creation for not funding the office appropriately?
Your Honor, I see that my time has expired. If I could briefly
Well,
answer.
my understanding is the Patent Office does a very thorough investigation and comparison, but from what you're saying, the Copyright Office doesn't do much.
Right, Your Honor. The Copyright Office does much less than the Trademark and Patent Office, and I'd like to point out for the court that in patent and trademark law, the statute says that an applicant may request registration, but here the Copyright Act has said may obtain registration. Thank you, and we would request that this court affirm the 12th Circuit.
Thank you. And I believe certain counsel did reserve rebuttal time, so we'll hear from the first petitioner.
Your Honors, Ms. Stierwalt has no answer to the question about how this court can grant such an expansive right to exempt sound recordings from the de minimis exception when the plain language consistently limits the rights of sound recordings. Further, although she advocates for this court to apply the quantitative and qualitative test, Ms. Stierwalt does not provide in the record any indication of how long her song actually is, which means this court is completely incapable of applying the test that she requests. Additionally, Your Honors, the average audience test is the appropriate test to apply here. Ms. Stierwalt incorrectly argues that the average audience test is only used to show factual copying. It is used to show factual copying, but it is also used to determine the second element, which is substantial similarity. And that test is correct to apply here because, as the Ninth Circuit noted in Ciccone, when the sampled sound is changed significantly, the average audience test is the appropriate test to apply. And under that test, the undisputed facts, like the fact that Ms. Stierwalt had a difficult time.
The puff noise wasn't changed.
Sorry, Your Honor?
The puff, there wasn't a transformative use of the snippet taken out here.
It's about how Your Honor, how the element is used in the new song. So it was significantly changed. Because
well, did he ever see copyright of his song?
I don't. I'm sorry, Your Honor. I don't know off the top of my head. I don't know if he did.
Because if you do and you contain elements of other people, you can put in material excluded and identify.
You can, yes.
Which would be analogous to him giving her acknowledgement. But we
Yes.
know he didn't acknowledge, so the question was whether he actually sought to copyright something that was hers. We don't know.
I do not know, Your Honor. But under that test, the undisputed facts, like the fact that Ms. Stierwalt had a difficult time recognizing it, show that an average audience could not recognize it. We ask this court to affirm the district court's rulings on the de minimis issues. Thank you.
Thank you, counsel. We'll hear from petitioner's rebuttal on the registration application issue.
Opposing counsel has pointed out that a majority of copyright applications are granted registration, but this does not negate or should negate the role of the Copyright Office. Perhaps a more clear illustration exists on page 6 of the record, Your Honors. This is the most recent statistics from 2016, which state that out of over 468,000 copyright applications, the Copyright Office has granted 414,000. Which, to illustrate a picture, Your Honors, means that 54,000 copyright applications were not granted registration, which means that 54,000 or a portion thereof may proceed without notifying the Copyright Office before instituting an infringement suit, which means that a portion of this number may have shifting legal entitlements, or that their claims may have inconsistent rulings between the Copyright Office and the court system. And a portion of that number, Your Honors, could be frivolous claims that are not necessary to bring to court. For reasons of judicial efficiency, Your Honors, this court should adopt the registration approach and affirm the ruling of the district court. Thank you.
Thank you. Was there a rebuttal reserved on this side? No? All right. All right. We'll stand adjourned and begin our deliberations. Thank you.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of the United States.
Ladies and gentlemen, before the judges return to announce the awards for our finalists, I would like to present awards to the participants of this year's program. First, I would like to recognize all the participants in this year's Moot Court competition. As I call each individual, please come forward to receive a certificate from Dean Guzman. Please hold all applause until the final individual has been called from each group. First, we have Natalie M. Selim, Madeline Anguiano, Allison Bach, Ryan Booms, Julie Gantz, Elena Gould, Vanessa Hahn, Kelsey Hill, Shelby Lindholm, Riley Mailman, Maggie Mendez, John Wong Moon, Michael Mottweiler, Anahit Meridian, Jin Kyung Oh, Mackenzie Pearson, Janet Shamilian, Peter Shelburne, Ashley Song, Jihyuk Song, Sarah Walkowitz, Caroline Wong, and Camille Yona. Please join me in giving them a round of applause. The next participants were quarterfinalists in this year's competition. We have Courtney DeClotz, Corinne Fierro, Kate Hom, Matthew Kordowski, Annalise Olson, Guggen Santu, Sharon Shulian, Laura Vaughn, and Caitlin Winkle. Please join me in giving the quarterfinalists a round of applause. The semifinalists for this year's competition were Victoria Littman, Taryn McPherson, Alexander Pinto, and Corey Randenberg. And our finalists for this year's competition are Stephen Ehart, Alyssa Mosscrop, Alexandra Jackson, and Alexandra Highsmith. Thank you, Dean. Thank you.
Great. And now that we've heard oral arguments, I'd like to go back and recite the facts one more time to make sure. No? Okay. I'll spare you that. At this time, the Executive Board would like to take a moment to extend our deepest gratitude to our faculty advisor, Rebecca Lonergan, if you'd want to join us on stage. Whose dedication and commitment as our faculty advisor has helped us make this year's program, as with every year she's been involved, extremely successful. We appreciate all your help and guidance. Thank you so much, Professor. We would also like to briefly mention USC's other Moot Court program, which is the National Moot Court Team. Each year, up to 10 top students from the Hale Moot Court Honors Program are selected as 3Ls to join USC's National Moot Court Team and represent USC in competitions and venues across the country in National Moot Court competitions. This year's team members include our very own Zoe Steinberg, Rachel Yang, Brian Bitzer, Dakota Spies, Emily Steerwalt, Yasmin Manners, Vanuhi Karapetian, James Nekraftar, Alyssa Tapper, and Nicole Boivar. Hopefully some of the participants you've seen tonight will participate in next year's national team. And finally, the board would like to give a special thanks to USC's technology department, particularly Dave Din and Christopher Kowalski for all their help managing our website and also for the recording of earlier rounds, as well as to Marie Cleaves, Aaron Johnson, Layla Landers, and Sabrina Montez in our events department for all their help organizing today's program. And at this time, I would also like to recognize somebody absolutely essential to this year's program. Without her dedication, leadership, and selfless commitment to Hale, this program would not be possible. Her constant attention to detail, strong work ethic, and planning were the driving force behind this year's competition, all while she continued to work during school, trained for a marathon, and placed runner-up in a national moot court competition. In a word, she is superhuman. Please join me in recognizing this year's chair, Zoe Steinberg.
And I'm going to go ahead and introduce the rest of our board, because this program simply would not run without the dedication and hard work of our entire board. First, the editors this year worked extensively with each participant to ensure that each brief and oral argument was the very best that it could be. Each of them went far beyond their role in attending oral argument rounds, facilitating practice rounds, and being advisors and contacts to the participants this year. Let's give a huge thank you to each of them. First, we have Aram Akimian. If you want to come on up. Our very own Emily Steerwalt. Melvin Lopez. Our very own also Nick Paul. Vanuhi Karapechian and Yasmin Manners. Our two topic editors worked throughout last summer preparing the problem for this year's competition. After several meetings and many drafts with the help of Professor Lonergan, they created an outstanding competition case for two very complex issues, as I'm sure you've seen from these arguments. Alyssa Tapper created the record arguing the de minimis issue, and Aaron Gilmore created the record regarding the application registration issue. The topic editors went above and beyond their role this year, holding office hours during the semester, being another set of editing eyes on just about everything, and taking on a much larger role than they signed up for. We were so lucky to have their help and enthusiasm. So please join me in thanking our two topic editors. I'd also like to recognize our two vice chairs on the executive board. First, our administrative vice chair, who's going to give himself his own certificate, has been a crucial part of this year's program. He calculated participant scores with his unparalleled Excel skills, managed our website and competition publicity, helped ensure that things ran smoothly at all seminars and at each competition round, as well as a number of other behind-the-scenes tasks to keep this program on track. His constant availability and can-do attitude was a huge asset to this year's board. It is my pleasure to recognize our Administrative Vice Chair, Tyler Franklin. And second, our program simply would not have succeeded without our Advocacy Vice Chair. She worked tirelessly throughout the year, ensuring that the program was on track. She was responsible for handling the logistics of each of the rounds, coordinated with the administration and professors, and made sure the participants had everything they needed to succeed in the competition. We could not have done this without her. Her dedication to our Moot Court program is undeniable and truly indispensable. It is my pleasure to recognize this year's Advocacy Vice Chair, Isabel Vidro.
So hi, I'm Isabel, and I'm the Advocacy Vice Chair. Each year, we ask the students in our program to choose one participant and one board member to receive an Outstanding Service Award. This award recognizes those individuals who have contributed to the success of the program in exceptional ways. The recipients of the Outstanding Service Award were nominated by their peers in the program for showing their dedication and commitment to our program's ideals throughout the year. They have been a helpful hand to many others in preparation for argument. They have been an outstanding asset to the program. At this time, we'd like to recognize Alexandra Highsmith. The board member selected for this award has been an incredible asset to the program. She went above and beyond her designated role to help and support participants as they made their way through the competition. I may be biased, but she has also helped write the best record this program has ever seen. For her outstanding contributions as a board member this year, we would like to recognize Aaron Gilmore.
Prior to the preliminary rounds of the competition that takes place in November, all participants submit a brief for their original side and issue. The law firm of Fox Rothschild has generously sponsored the Advocacy Awards for Best Brief, which are cash awards for the 4 participants who wrote the best brief for each party on each of this year's 2 legal issues. LexisNexis has sponsored awards to the 2 participants who received the next highest brief scores after the best briefs on each issue, regardless of which party they represented. On behalf of the Hale Moot Court Honors Program, I am pleased to announce these awards to the following participants. For the de minimis issue, the runner-up Best Brief Award goes to Michael Mottweiler. The Best Brief for the Petitioner goes to Stephen Ehart. And the Best Brief for the Respondent goes to Laura Vaughn. For the application registration issue, the runner-up Best Brief goes to Guggen Santu. The Best Brief for the Petitioner goes to Allison Bach, who unfortunately could not be here tonight, but we'll still give her a round of applause. And the Best Brief for the Respondent goes to Julie Gantz. Congratulations to everybody. You all did a fantastic job this year, and we are so proud of each and every one of you. And we are just waiting on the judges to come back with their final verdict on the decision. Oh, just kidding. So the champion today will receive the Edward G. Lewis Prize, a cash award endowed through a generous contribution from Edward G. Lewis, class of 1970. We would like to thank him for his generous support of our program. In addition, California Barbary has provided an award that will go toward a California Bar Review course for the champion of this year's competition. The 3 other finalists today will each receive the E. Avery Carey Award, a cash award named after the late Judge Carey. And as soon as the judges come back, we will announce the winners of these awards. Thank you. And now it's time to announce the winners of these awards.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of the United States.
Oh, please be seated. Sorry. You know, first of all, let me just say that, you know, what an honor it's been for me, and I'm sure I speak for my colleagues, to have presided over the oral argument this afternoon. It was not, for any of us, an easy case. Some of us have had some experience with respect to copyright law and intellectual property and so forth, but it's not your run-of-the-mill case that you would see in federal court. Fortunately, in the Central District of California, you do see more cases like this involving copyright, trademark, patent, intellectual property generally, but those can be very difficult cases. So I think that all of you did a very commendable job in arguing the respective positions of your clients. You were all very poised, obviously well prepared, much better prepared than I think any of us were. But I know you've lived with this issue for a long time. But I can tell you that it was a challenge for us. I can only imagine how much time that you all put in dedicating yourselves to learning the law and the facts in this case. So I foresee a very prominent and successful future for each and every one of you in terms of oral advocacy and success in the profession. You knew the law, you knew the record, and if in certain instances you did not, if something was not in the record, you conceded that, you acknowledged that, and you moved on. You were all very responsive to our questions. You showed very able thinking on your feet from questions that weren't necessarily submitted by us in advance or sort of with anticipation. Although we did, separate the two main issues in the case. Many cases have more than just two issues, but I thought that even if one of us interrupted you, you still pivoted onto answering the questions in a direct fashion. I think all of you maintained very good poise, voice modulation, and you, at least from our perspective here, you didn't seem overly flustered by what has to be really a very tense environment, and having questions come from the bench without any kind of a foreknowledge. So I really commend you. I commend the program. You've come a long way, as I see it, to reach the pinnacle of this final oral argument. So I think before we announce our findings or our ruling, I'll defer to my colleagues as to any additional comments they may want to add to what I've said. Stephen?
Go ahead.
Well, I want to thank USC, beautiful place to come to, and it's a pleasure for me, especially as a junior member of the panel, to sit with two justices. I'm the judge, they're justices. And both of them, if you heard their records, have given a great deal of service. So it's an honor for me to be with them. Also to the staff for the problem, it is a great one. If we didn't make it lively, it's probably because we didn't, the questioners, but you've got a thief in the Southeast, right? But he's a superstar artist in Los Angeles under the law on the first issue, correct? In other words, he would be in the Sixth Circuit, he is the thief, but here in the Ninth Circuit, he's an artist. Then you've got a split on the first issue, and then on the second issue, you've got the Fifth Circuit, my court, with the Ninth, which never happens. And you had some real darlings of the law. You've got a de minimis issue, as opposed to plain language. You've got statute of limitations and exhaustion, bright line rules, or do you have sort of recognizability rules? And then the underlying factual matter, the music and the industry and the internet, and do we update law? It was just a terrific problem. As for the four of you, and I do fair number moots, you guys are fantastic. And I'm sure, I hear that often, but it really was distinctive here. And I want to do a little apology and then an explanation. The apology is sometimes when I'm asked to do final round of moots, the people in front of you are so good and they've been doing it for so many months. I sort of guess that in front of your family and others, you want quirky questions. You want ones that are not almost autopilot for you, so you can display yourselves. Related to that, the thing we were talking about a teeny bit is, you must realize we never score attorneys. That's irrelevant in the law. The issue gets decided. We never do minute. Now, it's very important to have all the qualities, but you guys, in terms of presenting the issue persuasively, which is the important thing in real life, we're all glittering. And you could easily turn around and score us, because you know this issue so well. Did we ask questions that didn't make sense, but you couldn't tell us that? Or those things, which often happens. Or did we, more importantly, I'm really curious always to know with students who have such command of an issue, do you feel we appropriately got to where you knew you had your weakest point? So again, that would be you grading us as judges. Did we have command of the material to ask the hardest questions? Quickly on each of you, just positives, because I was so impressed, so I scribbled them down. Mr. Earhart, is that pronounced correctly? Ehart. What you were really good at was handling tough questions, because I did throw a sort of weird one, de minimis and con law, and then a factual one that wasn't in the record. Did this guy apply for derivative authorship, and what did he do? You didn't get nonplussed at all. So I love it when attorneys are willing to take on difficult questions, don't hide from their weaknesses, especially in briefs. You'll see attorneys drop hard questions into footnotes. It's just a natural aptitude to try to dodge a little bit of hardness. That's certainly not your, so I would say keep on with your confidence. So I tried to say, your client's a thief, your client's a thief, and you kept saying, there is no harm here. I thought that was very strong. Ms. Jackson, you were, correct me if I'm wrong, for Respondent, is that correct? The Respondent, yes. On the de minimis issue, you probably know, what did I like most? What did you do that was really clever? Yes. You want to flatter judges. I felt it was like car talk. You know that little, the triplet brothers, what are they? I said, in good lawyers will do that. They'll try to sort of take what a judge is saying to an opposing counsel and then embrace that as their strength. So you started with that. It sort of flatters the judge's ego as if it matters. The other second thing that you did, which was really good, was I thought the Sixth Circuit on your issue tried to really say thief, 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 moral outrage. You didn't go too far with that. You did drop in piracy, but you didn't try to overstate the point, the morality point here, because you made your points legally. You also gave context. I think you had some questions towards the end just about the whole copyright law, and you gave great context and then brought it back to our issue, Sixth Circuit. So second issue, Ms. Moskrop, is that pronounced correctly? Yes, okay. When I joined my court, Carolyn King told me, Steve, because I was nervous to start deciding cases, and she said, Steve, if you lawyer the case, 99% of them will answer themselves. You won't need to judge them. And you have a fantastic lawyer's manner. Just look at your rebuttal argument. You went right to the record to establish back a theme. And before I joined my court, there was a legend named Alvin Rubin. He's written a lot about great judging. And he said, lawyer, you want to sing a melody that the judge just gets in their head. And in the shower, they're thinking your melody. Somehow you had me feeling sorry for the Copyright Office. I really don't, but so that was impressive. Ms. Highsmith, and you were favoring a Fifth Circuit rule. So you had me sort of at start. But the biggest strength I saw in yours, which is a fantastic strength, is you break answers down into multiple parts. So you lay it out for us. That's very effective, because if a judge comes in with a preconceived answer, but then the lawyer says, well, I have 3 separate responses to that. And then that forces the judges to cede their time, and you get to elaborate 1, 2, 3. So you think very, very structurally, which is powerful in the law. The Solicitor General's office has some very basic guidelines for appellate advocacy, and one of them is always moot. Well, of course, you've mooted a million times, leading to the desired ability to have what's called rehearsed spontaneity. The answers seem spontaneous, but you've rehearsed them. And as I watched you, I thought, wow, she isn't getting flapped by anything. We haven't found a point, nor at the end did I feel you hurried up. You see a lot of lawyers, they realize, oh, I've answered their questions, but I haven't been able to make my points. You stayed calm right to the end. So there seemed to me that you conveyed the impression, we've covered it all. I'm ready to sit down. So all 4 of you, I hope you go into appellate advocacy. You'll be as good as you were tonight.
Right. Steve?
Well, I agree with every comment that both of my colleagues have made. And generally, to the four of you, it is clear to me that I'm looking at four soon-to-be lawyers that are going to make a mark on your world, wherever you find your place in our profession. And I want to say something about our profession because it needs to be said here today, and it needs to be said at this law school, and needs to be thought about every day. And that is that what we do, what we are sworn to do as lawyers and judges and law professors, and that is the rule of law, the art of advocacy, and the way that we have changed this country, our profession. If you stop and think about what happens in courtrooms all over this country every day, courtrooms all over this country, there are advocates in the courtrooms, and I consider it to be a work of art. It's just as beautiful as any painting in a museum or a symphony in a concert hall. What lawyers and judges do in courtrooms all over this country every single day. In our profession, every great document, lawyers were there. In the history of this country, every move in civil rights, in social justice, lawyers were there in the lead. And that's what we're all about. And so you guys are getting ready to join this profession, and it is noble and it is majestic. I leave you with one aspirational comment that I share with law students in Oklahoma, and it is aspirational, but that you learn in your life as a lawyer and a judge or a professor, that you learn to love justice more than you love victory. To love justice more than you love victory. And it's aspirational, but keep that in mind. You guys have great futures ahead of you.
Thanks, Steve. And you use a metaphor, a work of art. I've often compared oral advocacy is really an art as opposed to a science, although there is some science involved. And as I see it, all of you today are masters of the art, and I would continue your interest and practice in oral advocacy. All right, I think we've reached the time when I can announce that the panel here has discussed and deliberated very carefully, and we've reached I want to say a verdict, but we've reached a decision concerning the first runner-up, and that person is Alexandra Jackson. And for the winner, although all of you are in fact winners of today's competition, but the panel unanimously agrees that Alicia Muskrop is the winner of today's competition. Congratulations. And let me just say that our deliberations and our conclusions were not reached very easily, because I think I speak for the panel when I say all of you were extremely, extremely impressive and made the decision-making process here extremely difficult. But congratulations to all of you. Are we done?
So before we adjourn, I would like to thank our distinguished judges, Judge Stephen A. Higginson, Justice Carlos R. Moreno, and Justice Stephen W. Taylor, for taking the time to preside over our final round. I would also like to congratulate all the participants in this year's program. The program has been a terrific success. Finally, on behalf of the Executive Board, I would like to thank everyone for coming to today's event. I now invite Dean Guzman to say a few words in closing.
So I just want to join my voice to those congratulating everyone, in particularly the participants. You all guys did a really terrific job. Zoe, I think they only have 4 or 5 more rounds, right, before they're done? I want to congratulate Zoe and the board for the whole production, and Professor Lonigan as well. Thank you from me to the judges. We're so grateful you're here. For the participants, we're going to adjourn now. For the participants, please stay inside so we can take some photos. For the non-participants, please join us. There's a reception outside, and we hope you'll stay for that. Thank you to everybody. Have a great rest of the night.